If you and your partner aren't legally married, here's what you need to know. If something happens to you tomorrow, your partner could legally inherit nothing. Not your house, not your bank account, not even your car. And there are nearly 300,000 unmarried same-sex couples in the US right now, and most of them don't have the legal documents that would actually protect each other. I'm going to show you exactly which 5 documents you need, why each one matters, and how to get them before it's too late. Here's what we're covering today, and you need to stick around for all 5 because each one protects you in a completely different way. First, the one document that's the only legal way to ensure your partner inherits anything when you die. Second, the document that lets your partner make medical decisions in an emergency. Because right now, if you're unconscious in a hospital, doctors are legally required to ask your parents, not your partner. Third, the financial protection that lets your partner access your bank account to pay rent if you're incapacitated. And finally, the 2 documents that protect you while you're both alive, because estate planning isn't just about death. Let me tell you about a case from 2023. 2 women, Sarah and Michelle, had been together for 12 years. They weren't married. Michelle had been through a difficult divorce and didn't want to legally marry again. They owned a home together, shared bank accounts, built a whole life. Sarah died suddenly in a car accident at 41. She didn't have a will. Here's what happened. Sarah's parents, who hadn't spoken to her in 6 years because they never accepted her relationship, inherited everything. The house, the savings, her car, all of it. Michelle had no legal claim to any of it. She got 30 days to move out of the home they'd bought together. The courts didn't care that she'd been paying half the mortgage for a decade. Legally, she was a stranger. And this happens all the time. Now, you might be thinking, but we live together, we're on the lease, doesn't that count? Or maybe, we have a joint bank account, doesn't that protect us? No, it doesn't. When someone dies without a will, which is called dying intestate, state law has a very specific hierarchy for who inherits. And in every single state, if you're not legally married, your partner is not on that list. Your parents are, your siblings are, even distant cousins you've never met are on that list before your partner. The legal system doesn't care about the life you built together. It only cares about biology and legal marriage. And this is why these 5 documents aren't optional. They're the only shields you have. Document number 1, the will. There's one document that gives you the legal power to say, when I die, here's who gets my stuff. Without it, you have 0 control. And I need you to understand how devastating this is for unmarried couples specifically. If you're married, even without a will, most states automatically give your spouse at least half of everything. But if you're not married, your partner gets nothing. Not 50%, not 10%, nothing. Your estranged family, the ones who didn't come to your commitment ceremony, who don't know your partner's name, who you haven't spoken to in years, they inherit everything by default. A last will and testament prevents this nightmare. It's the legal document that lets you explicitly name who inherits your assets. You can say, I leave my house to Michelle. I leave my savings to Michelle. And here's what most people don't know. A will also lets you nominate a guardian for your children. If you're a parent and you don't have this, a court could give custody to a family member instead of your partner, even if they've been raising your kids together for years. You can create a will through an online service like Trust and Will for a few $100, or work with an estate planning attorney. I recommend an attorney if you have significant assets or complex family situations because they can make it bulletproof. Now, a will only kicks in after you die. What about while you're alive? What happens if you're in an accident and unconscious? Who makes medical decisions then? Document number 2, Healthcare Power of Attorney. Imagine this. You're in a serious car accident. You're unconscious in the ICU, and doctors need to make critical decisions about your care. Whether to do surgery, whether to put you on life support, what medications to use. Who do they ask? You'd assume it's your partner, right? The person who knows you best? Wrong. Federal law requires hospitals to follow a specific hierarchy for medical decision-making. And unless you're legally married, your partner is not on that list. Your parents are, your siblings are, your adult children are. So right now, in 2026, if you don't have this document, your partner has no legal right to make medical decisions for you, even if they've been by your side for 20 years. And here's where this gets even more painful. Your family can legally bar your partner from even visiting you in the hospital. I've seen partners locked out of ICUs while the person they love is dying because estranged parents said no. The document that prevents this is called an Advance Healthcare Directive, and it includes a healthcare power of attorney. This is where you explicitly name someone, your partner, as your healthcare agent or healthcare proxy. This person has the legal authority to make all medical decisions on your behalf if you can't make them yourself. Federal law, specifically the Patient Self-Determination Act, requires hospitals to honor this document. It doesn't matter what your family wants. Your healthcare agent is in charge. You can also include your specific wishes in this document, whether you want to be on life support, what your end-of-life preferences are, even instructions about pain management. And here's a critical addition for the LGBTQ community. You can include language that directs medical staff to use your correct name and pronouns, regardless of what's on your legal ID. This protects your identity and dignity even when you can't advocate for yourself. So, we've protected your assets after death with a will, and we've protected your medical decisions while you're alive. But there's still a massive gap: your money. Document number 3, financial power of attorney. Let's say you're in that same hospital scenario. You're recovering, you're going to be okay, but you're out of work for 3 months. Your bills don't stop. Mortgage is due, car payment, credit cards, utilities. Can your partner pay them from your bank account? No, not legally, not without this document. Even if you have a joint bank account, most banks will freeze individual accounts when someone's incapacitated. And if your name is the only one on a retirement account, a brokerage account, any solo asset, your partner has absolutely no legal right to touch it, which means they'd have to go to court, petition to become your legal guardian, wait weeks or months for approval, spend thousands in legal fees, all while your bills pile up and your credit score tanks. The solution is a durable power of attorney for finances. This gives your partner the legal authority to manage your financial affairs if you become incapacitated. They can access your bank accounts, pay your bills, file your taxes, manage your investments, even sell property if needed. The word durable is key. It means the document stays in effect even if you become incapacitated. Some powers of attorney aren't durable, which makes them useless. You can make this as broad or as limited as you want. Some people give their partner full control over everything. Others limit it to specific accounts or specific actions. Your choice. But without this document, your partner would need a court order to access your money. And in an emergency, you don't have time for that. Okay, we've covered the big 3. But there are 2 more documents that specifically protect unmarried couples. Document number 4, HIPAA waiver. Quick question. Can your partner call your doctor and ask about your test results? Legally, no. Not unless you've given explicit permission. There's a federal law called HIPAA that protects your medical privacy. That's usually a good thing. But it also means doctors, nurses, hospitals, and insurance companies cannot legally share your medical information with anyone unless you authorize it. For married couples, most healthcare systems assume spousal access. But for unmarried partners, you're legally a stranger. Your partner can't get information about your diagnosis, your medications, your treatment plan, or even which hospital you're in unless you've explicitly given permission in writing. I've heard horror stories of partners being told, "I can't confirm or deny that this person is even a patient here," because there was no HIPAA authorization on file. The document is simple. It's called a HIPAA authorization, or HIPAA waiver. It's literally a form, sometimes just 1 page, where you name the specific people who are allowed to access your medical information. You give this to your doctors, your hospital, your health insurance company. Most healthcare providers have their own HIPAA forms, but you can also create a general one that covers all healthcare providers. Many people include this language directly in their Advance Healthcare Directive to keep everything in one place. This seems small, but it's critical. In a medical crisis, information is everything. Your partner needs to be able to talk to your doctors, understand your condition, and coordinate your care. All right, we've covered 4 documents that protect you in medical and financial emergencies. But there's one more that protects your relationship while you're both alive and healthy. Document number 5, Cohabitation Agreement. Here's a scenario nobody likes to think about. You and your partner break up. You've been together 10 years. You bought a house together. You share a car, joint bank accounts. You split expenses. Maybe you even started a business together. Now you're separating. Who gets the house? Who keeps the car? How do you split the savings? If you're married, divorce law handles this. Every state has established rules for dividing assets. It's messy, but there's a legal framework. If you're unmarried, there are no rules. You're about to enter a legal nightmare where you have to prove in court what you each contributed, what you each own, what's fair. I've seen these disputes drag on for years and cost tens of thousands in legal fees, all because there was no written agreement. The document that prevents this is called a cohabitation agreement or domestic partnership agreement. This is basically a contract between you and your partner that spells out the financial terms of your relationship. It covers who owns what property. Is the house 50-50, or did one person put down the down payment? How you'll handle shared expenses. What happens to jointly owned assets if you break up? Whether anyone's entitled to financial support if you separate. Think of it like a prenup, but for unmarried couples. Now, I know this feels unromantic. Nobody wants to plan for a breakup when you're in love. But this document isn't about pessimism. It's about clarity and protection. Because if you don't have this conversation now, when things are good, you'll be forced to have it in court later, when things are hostile. And trust me, that's 1,000 times worse. So those are the 5 documents: your will, your healthcare power of attorney, your financial power of attorney, your HIPAA waiver, and your cohabitation agreement. Each one protects you in a different way. You can't just pick one or two, you need all 5. Because without your will, your partner gets nothing when you die. Without your healthcare directive, your family makes your medical decisions. Without your financial power of attorney, your partner can't access your money in an emergency. Without your HIPAA waiver, your partner's locked out of your medical information. And without a cohabitation agreement, you're one breakup away from a legal war. These documents are your shield. They're how you protect the life you've built together in a legal system that still doesn't fully recognize unmarried partnerships. And if you found this helpful, share it with your partner. Send it to your unmarried friends. This is information that could literally save someone from a legal nightmare. I'll see you in the next one.